on the agenda is the approval of minutes for the Planning Commission meeting of December 9th. Is there a motion to approve the minutes as presented?
I'd like to move to approve them as presented.
Do we have a second?
I'll second.
All those in favor say aye.
Aye. Aye.
Any opposed? Okay, motion carries. Let's see, do we have anyone signed up for public comment? Okay, and so next is Commission for Citizen Involvement, general updates. And all I have is an invitation from the Lake Forest Neighborhood Association. The Lake Forest Neighborhood Association invites you. Dessert potluck, winter meeting to follow on Thursday, January 23rd at 6:30 p.m. at River Grove Elementary School at 5850 McEwen Road. I think I pronounced that correctly. We are excited to host at the newly completed River Grove Elementary School. Please bring a dessert to share. All ages are welcome. Children, please attend with a responsible adult. 6:30 p.m. is a tour of the new school. A Lake Oswego School District representative will meet us in the cafeteria to provide a brief tour. Then at 7 p.m., meet back in the cafeteria to discuss more neighborhood updates, LOSD bond update, Q&A, Lake Grove update, parking, citywide parking reform, housing production strategy, metro housing project, parks and nature, Friends of West Waluga Park, City Sewer Line Project, West Waluga Park. Updated bylaws proposed to allow for more digital communication and flexibility of volunteers. Bylaws will be voted on in the meeting and can be found here at tinyurl.com/LFNA bylaws. Please enter the school through the main entrance and follow the signs to the cafeteria. Basketball practice will be in the gym and the parking lot may be busy. So if you want neighborhood updates on email, lakeforestchair@gmail.com and request to be added to the email list. Follow the Lake Forest Neighborhood Association on Facebook at facebook.com/lakeforestna. Do we have any other updates? Before the work session?
Yeah.
Okay. Okay, so going back to the election of chair and vice chair, the nomination and election of chair and vice chair for calendar year 2025.
All right, well, now's sort of the first time that we're going to be on the new kind of rhythm and cycle for election of chair and vice chair with the new sort of boards and commissions rules that were adopted not too long ago. So I would just remind folks that the current chair and vice chair can continue to act in that capacity. That's totally fine if you want just to nominate the same configuration, but of course, other folks can feel free to step up and volunteer, or folks can, of course, nominate others if they think that would be, they would be receptive to that nomination. So I'm not going to get too involved with things, but I would just throw it back to the commission for sort of some discussion and potentially volunteers or nominations for chair and vice chair.
What is the term? Can you clarify?
It'll just be for this calendar year. So we would then elect again January of 2026.
So January to December.
And they
They can't run again.
Oh, and you couldn't have consecutive terms as of 2026. So you couldn't, you know, we're allowing this because it's kind of the last time we elected was, I think, in the summer. So, you know, you can continue to serve after that half year, but 2026, we'd have to elect a new chair and vice chair.
Okay. I think you can't serve more than 2 consecutive terms. That's my understanding. So, if you were both to serve the same terms this year, then next year you definitely would need a new chair and vice chair.
Well, I would like to open it up to give someone else an opportunity to chair. It's such a wonderful experience. Do I have to nominate someone? Do we have any volunteers? Everybody jumping in at the same time.
In that case, it might be appropriate to throw out some nominations.
Okay. I would like to nominate the vice chair to be chair.
Is there a motion or, I guess, a second for that of some type?
I would second that nomination.
I guess is Vice Chair Mitchell willing to become Chair Mitchell?
I don't know if we were going to like deliberate the motion or not, and then I can speak up. It's, yeah, I mean, if nobody else wants to do it, I'll do it. That's fine.
Thank you. Do we have to vote on it?
Yes.
Yes.
I hear Evan, but I don't see him.
He's on the screen today. Evan is joining us remotely.
So we have a motion and then we have a second.
I'll second it.
All those in favor, say aye.
Aye.
Anyone opposed? Okay, motion carries. And so now we need a vice chair.
Somebody's got to volunteer for this.
Someone's got to volunteer for this. Do we have any volunteers? Before you get voluntold. I mean, sorry, nominated.
I'll volunteer.
Yay. So,
I'll move for Commissioner Najak to be appointed vice chair for the 2025 calendar year.
we have a motion. Do we have a second? I'll second. All those in favor?
Aye.
Anyone opposed? Okay, motion carries. There we go. We have a new chair and vice chair starting when?
Starting essentially next meeting. So,
Next meeting in
Yes.
February?
well, it'll be the first or the second meeting in January. Although, Evan, I'm not sure, does it
Oh,
take place
sorry.
now? Is it effective now?
No,
Okay.
next meeting is fine.
Okay, thank you. Okay, so where did we leave off? We have next on the agenda, we have thank you very much to our new chair and vice chair. Appreciate it.
Thanks for being a fantastic chair for the last calendar year.
Oh,
We
thank-
appreciate all your hard work.
You're welcome. Okay, so next on the agenda, we have a work session, the Community Development Code 2024-2025 Annual Amendments, work session number 2, LU 24-0029. The commission will receive an update, review the proposed amendments, and ask for clarifying or background questions prior to conducting a public hearing tentatively scheduled for March 10th, 2025. Staff coordinator is Evan Fransted, senior planner. Evan? Nope, can't
There we
hear
go.
you.
There we go.
There.
Thank you. Good evening, Commissioners. As Chair Moreno just said, she already said the purpose of it. This is to go over everything else we need to know before the public hearing on March 10th. For reference, the staff memo that went out on January 2nd provided background and summarized the maintenance items and the substantive policy amendments that we'll be talking about tonight. And there's a matrix of all the proposed amendments with commentary was included as attachment 1. So tonight we'll be reviewing each amendment, each item briefly and discussing the implications before moving on to the next one, similar to how we did in the first work session. So we have a lot to cover tonight. I'll try to move it along. I don't know if you remember, last time we had 27 items. Tonight we have 24, but we want to go into more detail about some of them because discussion is required. But as a reminder, they're broken up into two different parts. We have the maintenance items, which the purpose is to clarify existing standards for operational efficiency and consistency with other codes and address changes in state and federal law. Policy amendment items are substantive code amendments that require more research, public input, and discussion. So we'll start with maintenance items. first, and then we'll move on to policy items. The items are listed based on code citation, not ranked by importance. The first item is non-conforming roof changes. As we talked about in the first work session, this item came from our permit review specialist. The current standard allows for a change in roof pitch to not more than 6 feet. The issue is that the standard could be misleading to suggest that the 6-foot height increase could include a wall increase when the intent was to retain the top plate and only allowed a change in roof pitch. So we added, above here is the code language that would fix that, and a diagram that clearly shows the top plate cannot be raised. I guess it could be lower, but not raised. And you can move the roof pitch back and forth, but you can't increase overall wall height. So hopefully this clarifies the issues that we were having before. Are there any questions or feedback on this one? Okay, thank you. Moving along here. Item number 2. This is the commercial mixed-use, industrial, and special purpose district use table, which lists retail sales in 3 separate rows tied to gross floor area. In the IP zone, retail is noted as a C for conditional use, while with a note, footnote 5, which calls out sub-area in IP zone where there is an expanded list of uses. Footnote 5 states retail sales in IP zone sub-area are permitted if equal to or less than 35,000 square feet. A possible code amendment would be to amend the use table to add a P in the IP zone column for retail, since it is permitted in sub-area of the IP zone. Any questions on this one? Okay, moving along to number 3. Current code states that certain architectural features such as roof eaves, gutters, bay windows may project up to 2 feet in your required yard or into required open space as established by the lot coverage standards. However, this is not consistent with the definition of lot coverage, which does not include building features to project into open space. The reference to open space and lot coverage should be deleted. Any questions or comments on this one? Okay, moving along here. Item number 4 deals with a required parking lot buffer in the Lake Road Village Center overlay of 10 feet. This amendment would clarify that the parking separation buffer requirement only applies to surface parking and not enclosed parking within a building. It does not make sense to apply the separation to a building that has upper floors above parking or where the standard yard setback is less than the 10-foot buffer. Any questions or concerns about this one? Okay, item number 5. This one incorporates applicability sections of 50.06.12A1 into table to clarify those standards applied to residential development high-density zones and adds the R3, R2, R0 zones to that table to basically, so both codes applicability sections match. Any questions about this one? Okay, item number 6. This one was, the access spacing requirements were already moved to Chapter 42 with a previous non-CDC code amendment. So this just removes redundancy that is in Chapter 50 because it's in Chapter 42. All right, number 7. There are no private street standards anymore in the code. Any reference needs to be replaced with street or access lane in keeping with the 2022 code amendments. So this would just clear up those inconsistencies and just say street or access lane. Any questions about this one? Okay. Item number 8, similar to previous item number 6 for access spacing requirements, Chapter 42 already covers the distance of a driveway must be placed from an intersection with access spacing and site distance standards. The transportation system plan proximity guidelines range from 50 to 150 feet, depending on the level of service of street. The proposed code amendment references Chapter 42 for consistency. Any questions or concerns about this one? All right, item number 9. So this has to do with overlays. 3 of the design district overlays include complex discretionary standards or a clear and objective route for housing, neither of which can be reviewed as a ministerial review with a staff decision with no public notice. Therefore, single-family middle housing in those overlays must be reviewed as a minor development. The ministerial and minor development review procedures are proposed to be amended to clearly list those overlays as minor development. Also, this item removes redundant minor development item for residential infill design, which we call RIDS, variances, in RDD, DRD, and Lake Grove Village Center overlay. Any questions on number 9? Keep moving along here. Item number 10. This item corrects a reference error and clarifies which non-residential development qualifies for ministerial development review. So we just add to it and remove the bad reference that was in there before. Any questions about this one? Okay. Item number 11. This came from the Development Review Commission tree appeal finding that the current reference to tree cutting Chapter 55 does not include tree protection. To codify the interpretation, the reference to tree cutting chapter should be removed and replaced with a removal and specifically reference the tree removal standards in Chapter 55.02 to make it clear that tree protection does not apply. And item number 12, there's a conflict as to the major development versus minor development procedure process to modify designations of sensitive lands for a small number of parcels. This item would clarify that if the resource designation is being modified under the map correction criteria, then the application is processed as minor development. Any questions or concerns or comments about this one? Okay. Item 13. This has to do with the access lane buffer. This item clarifies that a house cannot cantilever into the required 5-foot landscaping strip required along the access lane for a flag lot. There's also a question if a 2-foot building eaves are permitted to encroach into this landscape strip as is permitted to allow in yard setbacks for building encroachments. Staff concluded that this does not apply to landscaping and that sufficient height is needed for clearance to grow plants in order to provide required screening. So this clarifies that no, a building cannot cantilever into the landscaping and the building roof eaves of 2 feet also cannot as well. Any questions about that one? Okay, item number 14. This was raised by code enforcement staff. This item would revise enforcement and penalties to strengthen and clarify what constitutes a violation. Additional text is needed to state that violations are also civil violations as defined by and enforceable by pursuant to Chapter 34. Any questions about that one? Okay. All right, item number 15. This one is a little more complicated, but it's still just a maintenance item. So this item will clarify that the entire building envelope must be located behind another lot to meet the definition of a flag lot. On the right, this is a partition plat that we received. It shows a typical flag lot. So the parcel 2 is clearly located behind parcel 1. It's accessed by an access lane. This is typically what people think of when they think of a flag lot. But it gets more complicated when you have street frontage. So this is a hypothetical 3-parcel partition. Parcel 1, even though it's narrow in the front, it's not located behind, the buildable area is not located behind another lot. Either is parcel 2. Parcel 3 would be considered a flag lot under this code amendment because it does include an access lane that serves, as I tried to show there in the gray, that's an access lane. It would serve parcel 2 as well. So parcel 3 is served by an access lane, and the majority of the building envelope is behind parcel 2. So this would be considered a flag lot with the code amendment process. And to clarify, so this would be the recommended code amendment. So it just says the majority of the building envelope instead of site must be located behind another lot, and it clarifies lot under there for the access lane. Any questions or comments about that one? All right, last maintenance item for native plants. The native plant list lists snowberry and Douglas spirea as trees, which is incorrect because they are shrubs, and should be moved to the shrub section of the plant list. So that's what this one does. I think that one might be the most straightforward one. All right, so moving on to the meaty part, policy amendments. So from our previous work session, 3 items were removed, as I mentioned in my memo. So those were previous item number 1, which involved code violations. This was removed because it was already covered in maintenance item number 14. It wasn't no longer needed. And then previous item number 5 for home occupations, this was moved to a separate tract. You will see this at the work session number 1 on January 27th. So you guys will talk about it then. And then previous item number 7 is sensitive lands mitigation. This was removed and will be addressed with upcoming tree code amendment project. So everything's been, for the policy items, has been renumbered. Hope this all makes sense. Do you have any questions about that? No? Okay. Moving on to number 1. We talked about this last time, but this has to do with non-conforming standards. So the current code requires that if a proposed addition or remodel of a non-conforming dwelling increases the floor area by more than 50% or more, full conformance with the current zone dimensional standards and design standards is required, or the applicant may choose demolition. This is contradictory to the purpose of the Historic Preservation Code. So this code amendment would add an exception for non-conforming standards for historic landmarks. To be clear, this does not change the historic standards. Everything else would still apply. This just removes that from the non-conforming section. So any concerns or questions about this one? Okay. Item number 2. This has to do with reconstruction of non-conforming commercial, industrial, and multi-family non-conforming structures. So I list up here the recommended code amendments. It's pretty simple. So the previous code amendment process in 2014 unintentionally made the limitations on reconstruction of 50% valuation of the existing non-conforming commercial, industrial, multifamily structures only apply to natural disasters, not removal or demolition of portions of a structure for reconstruction. So this would change that. I would add it back in. Currently, the regular non-structural maintenance or on a non-residential structure is only permitted or the structure can be brought in full compliance with the code. Staff feels this is overly restrictive and not the intent of the original non-conforming code amendment. So this would clarify that the reconstruction of those structures, including removal or demolition of a portion of a structure, is allowed beyond damage of a natural disaster. Any questions or comments on this one? Okay, moving along. Cottage clusters. So this one we are going to need to talk about. So it's kind of there's a lot to this one. So this one considers if cottage cluster courtyards or parking should be required to be in a separate tract or easements over the lots for middle housing land divisions. So when a middle housing land division is proposed, should it be allowed in a tract or an easement? Or maybe we shouldn't regulate it at all. The concern is that owners of each cottage may treat the courtyard area as their own lot and may erect fences or other structures as if it's their private yard. The DLCD has indicated they believe both options are available to the applicant. An alternative to requiring a separate tract could be to impose conditions with the middle housing land division to prevent encroachment into the courtyards if easements are provided, which would be enforceable by the city. Staff reached out to developers of cottage clusters, as well as consultants and others with experience with the issue to get their opinion. It was generally acknowledged that the potential for people to treat common courtyards as their own yard and erect fences or other encroachments into the courtyard is an issue. However, several pointed out the issue can be addressed by reciprocal easements on the final plat of the middle housing land division, stating that each benefit lot has easement right to the use of the courtyard, and the lot with the courtyard will be burdened by the other's easements, as well as it being a code violation of the conditions of approval. All the developers stated they would prefer to have options of either a tract or an easement as is currently allowed. So the pros to this are locating the courtyard in a tract tends to be better for enforcement since cottage owners' property lines would not extend into the courtyard and encroachments would be clearer. The tract boundaries and lot lines for each individual lot are clearly shown on the plat and described in their deeds. This could reduce the number of violations because property owners would be more aware of where their lot lines are located. However, the tract boundaries are not marked on the ground, and the property owner still may not know where the lot lines are. The cons to this are requiring one over the other provides less flexibility for developers. It makes it hard to deliver the site plan that works with cottages. Requiring a tract means that the cottages have to meet the building code minimum fire separation distance of 3 feet from an internal lot line or fire walls. Staff did not find any city that requires tracks over easements at this time. If tracks are required, the city may be more restrictive than other cities, which could be a detriment to developing cottage clusters here in Lake Oswego. Requiring tracks over easements could be perceived as a barrier to housing in general. After hearing from development community and considering the advantages and disadvantages, we'll open up to PC discussion, but staff recommends withdrawal of this item and recommends just leaving the code as it currently is and allowing developers the option to put in a tract or an easement, however they see fit. But I am curious to hear what your comments are, so please, anybody can go first.
I can get my mic on. I remember us discussing this one in rather detail, and I think it's great. Went back to the development community, and we heard from the developers, and it seems they want flexibility, which I think is probably what we all want from a development perspective on this ground. So from my perspective, if staff is comfortable leaving the code as is, right, that withdrawing it sounds like the right option, right? The only reason I thought we'd want it to clarify is if staff and the city thought it was becoming an administrative burden because of not having that clarification in. So I'm long-winded way of saying if staff's comfortable, I think that's the right move.
Any other comments?
I remember this, coming up initially last year, and as I recall, Mr. Boone, opined at the time that this is really a non-issue in terms of, what people's rights are. And I would agree that we should just leave it as it is. I think this isn't terribly important.
Any other comments? Thank you.
You. Okay, on to item number 4, accessory structure setback reduction. So this is an ongoing issue with violations involving accessory structures that are placed too close to rear or side lot lines and not meeting the setbacks. So the current code allows reduction for smaller accessory structure to specific locations. So you can reduce it to 5-foot side and 3-foot rear if those structures are at least 40 feet from the street, separated from all buildings by at least 3 feet. And the accessory structure does not exceed a height of 10 feet nor an area of 600 square foot footprint. So this is an ongoing issue because code enforcement staff brought this to our attention. They felt that the building code definition for how they require an accessory structure permit is contradictory to this reduction allowance. And they also felt like the common height of accessory structure is 12 feet and that some violators do not understand the standards or do not understand the height is measured to the highest point, usually the peak of the roof, whereas the building code measures it differently. They measure it to the average, which actually allows a taller structure. So the two are very different. It doesn't appear that there's really much of a correlation. In doing legislative history, I went back to the start of the code in 1947, and there had always been some kind of provision that allowed a reduction to side and rear setbacks for small structures. They changed throughout time. So back in 1963, it allowed a side or rear reduction to 2 feet, if not more than 60, if at least 60 feet from the street. And it just kind of changed over time. And it was pretty clear going through all the code that it never was meant to match the building code requirement of when a building permit was required. It was just something that there's two different metrics. And I looked at other cities' standards and reduction to side and rear. It's a common standard in almost all cities. They all use similar metrics. There are a few cities that allow reduction to side and rear for accessory structures to 3 to 5 feet with a maximum height of 15 feet. So they actually allow a taller structure. So that was in Westland. Tigard. Oregon City had a maximum height of 17 feet with maximum area of 500, 600 square feet, so it's just more. At this time, staff does not find a direct solution to ensure property owners do their due diligence and understand that accessory structures do not require a building permit, still need to meet planning criteria and for these allowed setbacks. It may not be reasonable because of the different regulation purposes to match the building code permit requirement. When doing so would allow a structure up to 15 feet in height to be located 3 feet from the rear lot line when only a 10-foot height is currently permitted. As noted, the building code measures height differently, so it's just two different metrics. Staff recommends the following. So first one is public outreach. So implement a more effective public communication solution, such as a warning in the building permit package that the CDC standard still must be met regardless if a permit is required, something that's getting lost in the process. And create a handout that clearly differentiates the building code from the community development code standards. Second one, be curious to see what your opinion is on this. Allow a potential code amendment to increase the height to 12 feet. So this is based on code enforcement staff opinion that it would better align with the typical height of a prefabricated accessory structures and hopefully reduce the number of violations. Planning staff believes this additional 2 feet would generally not negatively affect neighbors. So yes, I'm curious to hear what your comments are on this one.
Jump in and ask a question. In the notes, it says for the proposed second option, increase allowed height, 12 feet to better align with the typical height of a prefabricated accessory structure. Can you talk a little bit more about that? Is that like the industry standard? Most of them make them to 12 feet?
Yeah, I guess the prefab ones, they do typically come in around 12 feet is what code enforcement has found. And so if you just buy one from Home Depot or wherever you're getting an ND, that'll be the height, but it won't meet the reduced setback standard. And I don't think, it sounds like people aren't understanding that.
Yeah.
So if we tried to match the industry standard of 12 feet, then maybe hopefully we'll have less violations.
Yeah, that's what I was trying to make sure I understood it correctly, is sort of, we have this, let's call it an industry standard for lack of a better term, of these accessory units being designed at 12 feet. But we have a code that says that doesn't allow anything over 10 feet in the setback area. But in looking at the history, we don't know exactly why that 10-foot threshold was put there 50 years ago. Did I have that right? Between 1977 and 1982, right? So, like, my preference would be to try to match what is the industry standard while understanding if there are cons related to an extra 2 feet. I see staff's note that says they would generally not affect the neighbors. So if we don't understand why the 10 feet was there, I don't think optically the difference between 10 and 12, 2 feet would make much of a difference. But again, that's just me speculating. So I don't know. I think of keeping the 10-foot requirement without having a real reason for it, it just doesn't make sense. Unless we can find a real reason, or neighbors have told us there's a reason that 10 feet is better than 12. I feel like we're just keeping it. We would just be keeping it to keep it because it's been there for 50 years, and in doing so, going against what is now industry standard of 12 feet.
And I will point out, they do make prefabricated sheds taller than 12 feet too. So industry standard, I just want to make clear that doesn't mean that that's all,
Yeah.
If you go to Home Depot, they have different varying size, but I think what we find is they tend to be, that's a very common one, let's put it that way.
Yeah, that's what you're seeing when running into these problems, and that folks are putting them in and they're
Generally, from our code enforcement's observations, that's a typical height. But again, we've seen people put a 15-foot one too, and that's a violation. So we aren't going to eliminate those. But no matter what, we need to have better information for the public. And so that's definitely something that we're going to do. So it's to make it clearer to the public. Right now, all that information is not buried, but we have an accessory structure handout that covers a bunch of different types of structures. But I think we want to have a special handout because these are so common that will just address this and make it crystal clear what the building code versus zoning code requirements are.
Well, then I guess do we want to do just option one? Because since it sounds like we're going to do better literature no matter what, is there a possibility of doing both, doing the better literature and then also just making it higher?
I think Mr. Boone may have something to say.
Well, I just wanted to, again, remind the commission, of course, that today is not to deliberate, and what you would be doing if you want to solicit public testimony on the 12-foot to see whether or not, that it comes out to, in fact, that there is a public perception of an impact, then you would go ahead and retain it. Otherwise, it's up to the staff. They could decide to just withdraw it and just proceed with the better information. I think what staff is looking for is whether there should be some public discussion of the impacts of this 10 to 12 at the next public hearing meeting or not. If the commission thinks that 10 feet is, from a public perception, is fine, then we might just, not move forward. But in any event, not trying to decide the issue, just decide whether it should go to public hearing for discussion.
I guess I would just reiterate that I think we're proposing both, that we would, combine that public communication with the sort of provision to the standard to increase that maximum height to 12 feet. So what we would propose, it's not necessarily options, we would propose both of those things, I guess.
Well, either
Well,
way,
they are
number one,
options, but-
yeah, either way, number one will happen. It's just a question of whether number two should happen as well.
And number one, public outreach, that doesn't mean having a hearing, which we obviously have to have, but we're talking about something separate. We're talking about doing brochures or literature or educating the public. Okay, got it.
Any additional comments?
I don't think an extra 2 feet, poses a huge problem, but it is a little bit, more of an impact on a neighboring property. Given that, I'm wondering if we have any idea about the rationale behind the 600 feet for the square footage.
Unfortunately not, no.
Because if we were increasing the height a little bit, could decrease the square footage a little bit in order to sort of compensate.
It might be beneficial to do similar kind of, interview with code enforcement staff to see if they have any experience of what a typical square footage is for a sort of prefab accessory structure. I'm not sure if, we wouldn't want to preclude them through, square footage if we're trying not to preclude them through height.
That's the whole issue in the first
Right,
place.
yeah.
Yeah. That would be interesting to look at.
Well, I think if I ask them, they'll probably say, because the building code requirement for when a building permit's required is 200 square feet, they're going to say it's 200 or less is what they see. But they also see, like Jessica pointed out, all different kinds of sizes that some do not meet the standard and they're placed too close to the property line and they're taller than that. And some are custom built. And so this is just trying to get to the more common ones, but won't catch all of them. So should we move forward with the 12 feet for the public hearing? Is that what I'm hearing?
That's, obviously, that's my vote.
Yes. I agree.
All right, sounds good. Thank you. Moving on here to number 5. I think the screen went dead. There we go. All right, so this item clarifies when the commercial building design standards apply for accessory structures. So the commercial building design standards are applicable to all structures, including accessory structures, but most criteria are applicable, specifically it says to buildings. Staff previously applied the complementary criteria of subsection 5B1, to all accessory structures, even though they may not be perceived as traditional buildings. This is a problem because some accessory structures without walls are not perceived as typical buildings. It might not be sustainable, it might not be suitable for design standards geared towards buildings with 2 walls and a roof. For example, accessory structures that may not be perceived as buildings, or as depicted here, is a fueling station without walls. It only has support posts and a roof. There's not really much of a design to it. However, it does meet the definition of a building. This amendment would clarify how to review accessory structures under the building design standards by adding this type of structure to subsection 5B3, which regulates similar accessory structures such as bus shelters, drinking fountains, benches, mailboxes. This would clarify that accessory structures have to be complementary to the building's design and character. Any questions or comments about this one?
regards to it being complementary to the building's design or character, does that mean that you would have to say, if you had an English Tudor style building, you would have to have a custom-made English Tudor bus stop?
No, that's not how we have interpreted that. It's more about massing in materials that they won't be completely different from, basically. But yeah, they're building structures like that are utilitarian in design initially, so we don't want to try to make something that it wouldn't fit anyway.
Yeah, because a lot of these structures are like a prefab product, so just want to make sure that we're not placing an additional cost burden to get a higher design standard on these than is necessary, but at the same time, keeping them safe and functional.
Yes. So it wouldn't change the standard, we just add these, make clear that these apply. But that standard for bus stops and has existed for years, and that's, yeah, we have never required it to match the style.
Thank you for clarifying.
Okay, item number 6. So middle housing land division classification. Currently, middle housing land divisions are subject to the same standards as other land divisions, so partitions and subdivisions, even though the purpose is to divide the land for ownership only, not for development. Use of the phrase land division is problematic where a number of standards are applicable but should not be to middle housing land division. Staff recommends clearly stating the applicable sections for each standard that do not apply to middle housing land divisions. So this would just clearly state that middle housing land divisions, like access standards, don't apply, and the list goes on. Any questions or comments about this one?
I don't have a substantive comment, but I didn't fully understand the purpose between dividing land for ownership and development. If you could just explain that.
I mean, yeah,
I can take that one, I suppose. You know, it goes back to when we adopted middle housing regulations. You know, we essentially also had to comply with Senate Bill, I think Senate Bill 1537, I believe, at the time. But essentially that required the city to allow these middle housing land divisions that you don't necessarily divide the property. You know, if you go back to that cottage cluster example, you wouldn't be dividing the property into additional lots that each have their own additional development potential. You wouldn't be adding allowed density to the lot with a middle housing land division. You're kind of just, as Evan noted, you know, dividing it up for ownership purposes. But our typical land divisions or subdivision processes would result in additional density. So it would be a larger lot that you would subdivide, you know, into multiple lots that could each have their own cottage cluster. Of course, you don't have to divide the lot. You know, if for a cottage cluster, you can just develop it all, you know, on one parcel if you don't want to divide it up for ownership purposes. But yeah, that's kind of the difference. Is one is increasing allowed density, and the other is kind of just cementing the allowed density that's already on the lot and in place.
Okay, that's helpful. Thank you.
next one is generators. So this is considering permitting minor variances to reduce required yards to locate a generator. So there are we had multiple pre-application conferences to locate generators in required yard setbacks. All requests under current code will require a major variance to reduce setbacks as proposed, which is extreme. These type of structures, it would be challenging to meet the criteria. Major variances are major in nature. It's a hardship variance where you have to show there's a hardship with the property, and it requires a public hearing. In researching other city standards, staff could not find any specific location requirements for generators, except in relation to telecommunication facilities. Generators are typically treated the same as any other mechanical equipment or accessory structures. Some cities do not have setback requirements for mechanical equipment in general if they meet certain screening standards. Some cities allow reduced setbacks for mechanical equipment as long as certain screening standards are met, like Portland. Most cities have some kind of variance that can be applied for if necessary. Staff did not find another city that required a major variance for generators or mechanical equipment in general. No research city had specific noise or fume standards for generators, except in relation to telecommunication facilities. Excuse me. Staff recommends adding a minor variance classification specifically for setbacks related to the placement of generators. The reasoning for this is generators run temporarily during power outages, and they turn on normally for normal maintenance cycles where the units, they just run temporarily. So this would have limited impact on surrounding properties compared to mechanical equipment, such as heat pumps or AC units, which run continuously. Please note this option would not limit the setback reduction to 20% or less or 5-foot setback as required for standard. We do allow those for typical structures. So they could reduce this more than 20% or be closer in 5 feet to a property line. This option would allow reduction to any setback as long as the minor variance criteria are met, which requires an analysis of public health and safety, material injury to surrounding properties, impacts to streetscape, and impacts to physical and natural systems. Minor variances involve a minor development application that requires a pre-application conference, public notice with a 14-comment period. It's a staff decision that could be appealed to the DRC and potentially a city council, but no public hearing is required. So any questions or comments on this one?
I wonder if I could get a clarification on whether anything related to an installation of a generator could potentially be considered to materially injure a surrounding property.
Well, I mean, this picture of this generator, so the scale is not great, but that's probably the size of a large refrigerator. It's pretty significant in size. In this case, it's located in the front yard, but as you can see, the lot is sunken below the street. They have a wall, they have vegetation. So in this case, the impacts would be not really to anyone. They would likely meet the variance criteria. Whereas if this was located in somebody's front yard next to your door, 3 feet from your front door, or 5 feet from your front door to the side property line, you might say that's materially injurious. I mean, that is an eyesore, right? So I think that there are some cases where you could find that it could be materially injurious. It could affect, they could argue, and I don't know if Evan Boone will correct me on this, but, someone could claim it could affect their property values because it's interfering with the front
Enjoyment
of
the
their front
property,
of their
yeah.
yard, like where everybody sees the area. So yeah, I think it is possible that it would be materially
Absolutely.
injurious.
And I'll just add in, Evan, here. In fact, I have a friend who had their neighbor do that, and he was very upset about it. And, so yes, you have a large refrigerator sitting in your front yard that makes noise from time to time, that could be materially injurious.
Okay. That's what I was wondering, because I am aware of situations where, I don't know what a typical generator is now, but especially older generators can be quite large, and especially if they run for maybe half an hour once a week, that was say outside your kitchen window or, your front door or something like that, that could be a problem. But, if that sort of thing could be taken care of under under the proposed option, then I think this seems appropriate.
Yeah, I think, the minor variance would attempt to, account for that and, require sort of alternate placement or screening or something of that nature. So I think that would hopefully account for that potential outcome or prevent that potential outcome.
And I guess technically I would add, of course, minor variance you can impose, that's a minor development. So conditions of approval can be imposed. And one of the conditions is impacts to the built environment. So definitely there's an ability to provide for screening, visual or acoustical if that was found to be the case.
And these are important for emergency preparedness, as we lose power and things like that. So we definitely want some flexibility for people to allow to have these as long as they don't negatively, materially injure anyone within 300 feet in terms of the surrounding neighborhood. So, and we have seen a few of these, unfortunately, that it made a lot of sense where they were proposing because it wasn't really impacting anyone, but we couldn't approve it because of they wouldn't qualify for a major variance.
Is there a lack of options to put the generators not in the setback because the house is taking up most of that area? That's why folks want to put them in the setback? Because I'm trying to understand how how important or critical is it for folks to be able to go into the setback?
We have a lot of non-conforming structures, non-conforming dwellings. I mean, just go along the lake. I would challenge you to find a house that isn't non-conforming along the lake. So the answer is yes. It's not that, a lot of these were built before we had code standards or when we had different code standards, and, things have changed over time. But yeah, that does happen a lot, unfortunately.
Is there also like a proximity factor here where the generator needs to be a certain distance from the home, or would it be possible to kind of put it, deep back in like the backyard setback? Like, is that even a possibility? I wonder.
Well, there's specifications for the type of generator you get for how close it can be to the house. I mean, some generators can actually be in garages. That's an option too. But it just depends on the type of generator and where they're at.
I found it curious that there's no research for noise. Like the research said there's nothing in the code pertaining to noise.
Yeah, so I guess it's good to reference that I think 5 years ago they changed the setbacks for mechanical equipment. And as part of that code amendment process, there was options to include some noise standards based on decimal level. And the Planning Commission and City Council decided not to do that from public comments and so it was an option they looked at and they decided not to.
It is very, very difficult to enforce that. Nobody has a decibel reader. Well, even if they did, I mean, staff, we need evidence. And, staff is not around 24/7 to be able to observe that. So that's one problem. It's also like, how long is it going? I don't know, Evan Boone, you might be able to add some difficulties with that, but it is a bit of a nightmare to try to enforce noise regulations based on decibels.
We don't do it. The current noise code does not do it. We had a discussion within staff to do that, and there are challenges. It's not a cure-all. Surprisingly, things are louder than you would think on the decibel level. So.
Yeah, and of course, this is, again, a piece of machinery that isn't operating at all times. It's pretty, isolated periods when it might be making that noise, so it might make it even more difficult to enforce than something that was more continuous, like a typical mechanical unit.
I would just say, though, that the acoustics of these things, I think, are more of a concern to a neighbor, and kind of what you were bringing up, than the aesthetics of it. And typically, if you do have one, you should be running it for about 20 minutes once a week. And if the power goes out, that's a whole different thing. But if you've got your at-home office and that thing is outside and it goes on for 20 minutes once a week, I'd see that as a problem, especially if you're trying to communicate with something and you got this, and they are loud. Evan, you're right. They're louder than you think, much louder than a full-on lawnmower. So I think, and there's really nothing in here about that. So are they becoming more, I would assume, more popular in Lake Oswego?
Yeah, I think the demand is rising as we're having these power outages.
Yeah.
The first was the ice storm a couple of years ago. That a lot of people wanted them after that, and then after last year's ice storm too. But again, we're applying the minor variance criteria where you look at impacts to surrounding properties. And as Evan Boone mentioned, you can have conditions on there that maybe if they're proposing at 5 feet, maybe you don't approve that. Maybe you can say, well, it needs to be 7 feet, or you look at the conditions on the site and what they're proposing, so they could provide, based on the manufacturer's specifications, how much noise this does produce and whether that will create issues. Or you can look at all of that and you can impose conditions to maybe correct some of those issues.
Yeah, the conditions would bring it down so it's no longer a material injury to the property. I mean, that's the criteria. So, yeah.
I will point out that, so a typical setback, so let's just say you're in a sort of low-density, single-family residential zone. Your typical setbacks are 25 in the front, That's from the street. 30 in the back, so typically it's abutting against probably most likely someone else's rear yard, so lots of distance, and then 5 feet on the side. A 5-foot setback on a side yard where the dwellings are typically closer on the sides does nothing for noise. Like, these setbacks were never designed
Right,
for
for something
noise
like this.
attenuation. It really is more of an aesthetic and just trying to kind of keep some separation between properties. So if you go from a 5-foot setback to a 4-foot setback, what's that gonna do for noise? Nothing. And if you're talking about a rear yard setback where if you're going, instead of 30 feet, you're at 25 feet, okay, well, again, I don't see that is gonna really do anything for noise attenuation. So it's understandable that that's a concern, but we've never had that type of standard that would address noise in our codes for these types of structures.
And of course, through the variance process, you could also look at things like adjacencies to windows and sort of, portions of the adjacent structure that might be closer to, the lot line where the generator would be placed. So there's more flexibility to kind of configure things through that minor variance process, I think, than that strict sort of decibel level enforcement.
Any other questions or comments?
How are you going to wrap this one up?
This one, the generators? Well, if the commission agrees, we'll move forward with the minor variance recommendation. For the public hearing, right.
That seems appropriate to me. Agreed.
Okay, great, thank you. All right, so this is the last one, but it is the biggest one, I guess, the lengthiest one to explain. The definition of detached. So bear with me, there's a lot of history here. All right, so during the 2023, we'll probably remember, last code amendment process, City Council approved amendment to clarify the definition of duplexes, triplexes, and quadplex to ensure that units are physically attached along common walls. There was discussion about the minimum percentage of the units must be attached. 25% was approved. But some councilors discussed that the definition of detached was confusing. The location of the common wall attachment between units was also discussed, and the City of Bend's definition was referenced. City Council directed staff to research the definition of detached and to see if it could be further refined as part of this code amendment process. So for reference, there's the definition for duplex, and that's a plan that shows compliance with those standards. So you have 2 duplexes, each are connected by at least 25% of the walls. So here's the definition of detached. So the definition of detached requires a horizontal separation of 3 feet or more between the subject structure and nearby structures. For example, if a garage is less than 3 feet from the primary structure, measured eave to eave, then the garage is considered an addition to the primary structure. It's attached. This is important when determining setbacks, maximum floor area, and lot coverage. The big one this comes up with is for garages, where if a garage is attached, it becomes part of the dwelling, and it has a 30-foot setback, your rear yard setback requirement. If it's detached in some zones, for example, this one here, the photo, it allows a 15-foot setback. So I took this photo at 4 o'clock today. So you can see it actually shows on the plans it's 5 feet. I don't believe it's 5 feet, but you can see the separation between the garage and the dwelling. And what it kind of functions as in between them and what it looks like up from the street. From all intents and purposes, when you look at the garage straight on, it looks like it's all one structure. This is what we're getting with the current code. So the definition of detached was added to the code in 2013. The staff commentary on the code amendment noted that the purpose of the detached definition is to require a separate distance which is meaningful in terms of visual separation between structures. 3 feet is the distance for structures required separation by the building code without a firewall. The 3-foot separation would not apply to breezeways, air conditioning units, heat pumps, and the like, and all the small attachments to a structure that do not result in the perception that the two structures are attached or joined. Staff also noted that the requiring 3-foot separation would prevent two buildings from being detached technically, and therefore benefiting from the accessory structure setbacks for one of them, while appearing visually as a single mass because they could be only inches apart. So the creation of the detached definition was really about defining when the accessory structure versus primary structure setbacks apply. So it's all about like, all right, so this is when accessory structures, how we define accessory structure. In research in other cities' standards, staff found two methods of defining attached versus detached. One method is to have a common definition of detached and detached, as was, Tigard, Portland, and Bend did do that. Other method is to include definition of attached in each specific dwelling type. So Westland, Oregon City, Milwaukee, Wilsonville, Gladstone, Tualatin do this. Oregon City defines single-family detached units as an example, as single-family detached residential units means one principal or primary dwelling unit per lot that is freestanding and structurally separate from other dwelling units on the site except accessory dwelling units. Currently, the CDC includes both methods, with a definition of detached and a definition under each dwelling type. So under duplex, multifamily, single detached, triplex, quadplex, townhouses, they all have their definition. Staff finds that with the definition of each specific housing type, the general definition of detached is no longer necessary and really only pertains to accessory structures. A logical solution would be to remove the definition of detached because as the council pointed out, it is confusing to define attached with a detached definition, which includes a minimum separation requirement of 3 feet. No other city research uses such a provision. It's also counterintuitive to define a structure as attached if they are physically separated, even if only by inches. One issue with removing the definition is how do we prevent accessory structures from being placed close to a primary structure or other accessory structures so they may appear attached as one mass? Is this still an issue? Staff has experienced difficulty with applying the standard over the years with measuring the distance between structures. Other considerations are that the resulting development includes a 3-foot area between the two building eaves that is mostly unusable space, often paved, and limits development on constrained sites. By not requiring the 3-foot separation, developers would have more options on smaller sites to provide housing which still have to meet required setbacks from lot lines and building code separation standards. Another issue with removing the definition of detached would be to lose the exception for breezeways, air conditioning units, heat pumps, and similar attached or connected fixtures to the structures that is part of the definition. This could be solved by incorporating the exception into the definition of accessory structure. As for Ben's definition of attached, considering there should be location standards where the dwelling should be attached, staff's opinion is that Ben's definition could be confusing to the applicant, and staff to implement with an ambiguous option that requires the entire length of one elevation to be attached. It is unclear how the entire length of one elevation is defined or measured. Staff finds that last year's amendments to the definition of duplex, triplex, and quadplex with a minimum 25% attachment between the common walls provides sufficient flexibility for developers' creativity in design without requiring a cookie-cutter approach. Plus, the definitions are so new that no project has been built yet to the standard and is too early to fully understand if there are any unnecessary barriers at this time. Staff is therefore proposing not to amend those recently adopted definitions at this time. So, keep moving here. So, definition of detached, staff is proposing two options, either or option, to refine and provide clarity when an accessory structure is attached versus detached. The first option is to delete the definition of detached and add to the definition of accessory structure that there must be no structural connection to the primary structure. The advantages to this option are it removes the difficult to implement 3-foot separation requirement and replaces it with a common terminology of structural connection. It also retains the same language excluding breezeways or similar connected fixtures. The disadvantages is that this option would allow accessory structures to be located closer than 3 feet to the primary structure if the building code firewall requirement is met, so you need firewalls, which may appear as one structure even though the allowed reduced accessory structure setback would apply. The second option simply clarifies detached applies to accessory structures. So we add accessory structures to it. The advantage is this, it provides clarity. The definition does not apply between dwellings. It only applies between the primary dwelling and the accessory structure, not between two dwellings or more. The disadvantage is that it does not fix the implementation issue staff has had, or that the resulting development includes a 3-foot area that is mostly unusable space and limits layout options on smaller sites. So at this time, I'd be open to hear your thoughts on this and which option you prefer, or maybe another solution. And if you want me to go back and forth between the two options, I can. So option 1, add to the accessory structure. Definition, delete the detached definition. Option 2, just add accessory to the accessory structure detached. Make clear that it only applies to accessory structures.
I think to sum it up, what we're trying to do is no longer have a situation where you can have two primary structures that are within 3 feet of each other that are considered detached. That shouldn't apply to that. This was all intended to be for accessory structures. So both of these options will take care of that issue in that it will only apply now to accessory structures. I think the difference between option 1 and option 2 is that option 1 doesn't require a 3-foot separation. It just requires that they not be structurally attached. The second option retains that 3-foot separation of the accessory structure from the primary structure. Did I get that right?
Yes, that's correct.
I think number 2 seems more closely tailored toward meeting that goal. I mean, if anything, based on, your example from 4 o'clock this afternoon, it seems like, one would want a larger difference in order to not make them appear as one structure. So, I mean, I don't know, that seems like maybe another can of worms to me, maybe a more, policy-related thing. So I would prefer option 2.
I would agree with option 2, preserving that 3-foot minimum. Just thinking about like fire and life safety, making sure that someone doesn't have a barbecue just like right up against their house.
That's actually sort of where my question was going, is like, what is the purpose of the 3-foot? Like, what do we want? What are all the pros for giving us this 3-foot separation?
Well, it was to provide a separation between the buildings so it didn't appear as one mass. That's why it was created. Because I think that before then it sounds like there was some accessory structure, maybe some sheds or something that were being placed, or garages right next to the primary dwelling, and they were taking advantage of that reduced setback when it appeared the same as attached. So the idea was separate them by 3 feet eve to eve, and that way at least it will appear to be 2 different structures.
And we care about the appearance because of it might impact other things like setbacks. I guess I'm trying to get like, why do we care whether it appears as one or not?
I think it effectively allows you to benefit, again, from that reduced setback and increases the overall sort of appearance and mass of the structure to a level beyond what was considered in the underlying zoning sort of design and dimensional standards. So that, it was kind of intended originally to close a loophole that the origin of that 3-foot separation was something that came out of that particular, that specific instance actually occurring in a neighborhood in the city, and folks trying to prevent it.
I just wanted, if the commission can hear me?
Yes.
Hello?
Yes.
Okay. I just wanted to remind the commission, you don't have to decide between option 1 and option 2 tonight, or the question is to clarify, to understand the options, and to decide whether to move both forward for public comment, and then you make your decision, or just one of them, and maybe you get public testimony about the other one that you didn't put forward, or there's a third option if you want to put forth some other option. but not to decide the issue. Have
Thank
to
you
wait
for
for public testimony.
thank you for the clarification. I'd be curious to hear public comment about both options. Anybody else?
I think, given that you do, we should probably go forward with both to the hearing.
And that, of course, would not preclude, after you hear public testimony from the commission from deciding, option 1 or 2 at the hearing.
Be opposed to that idea? So we'll move forward with both options. Okay, sounds great. All right, that was the last item, so now just schedule. Go back to my presentation. Oh, it's just up there, okay. So tentative schedule, so next up is our public hearing on March 10th, and the adoption of findings will be on March 24th, and hopefully it will go to be presented to City Council on April 15th. And that is our tentative schedule. So that concludes all I had to show you tonight. Thank you for your thoughtful input. And we have to answer any questions or any follow-up if you have any.
Thank you, Mr. Fransted, for the presentation.
Welcome.
Okay, do we have any other business? And schedule review.
Well, I had one question.
I'm sorry, go ahead.
Eric, any feedback from last week's big session at the, with everybody and talk about future thoughts? The big idea appeared to be food carts.
Yeah, it was an interesting meeting. So yeah, the Boards and Commissions Summit was held last week on Thursday night, January 9th. And there were some surprising conversations had during that event. But, we heard a lot about, of course, a lot of issues that we frequently discuss at the Planning Commission, including, the limited availability of land for growth within the city and the challenges that poses. There were a lot of really good discussions and ideas. There was some excitement about the potential for development in the Foothills neighborhood, and that's the project that we have on the docket for this year. But one of the more sort of, one of the outcomes that we did not necessarily see coming was that, we all broke out into different groups and, had different sort of isolated group discussions. I'm not sure if we could overhear each other, but they were all kind of independent discussions, and folks independently all kind of came to different forms of recommendations for the city to look into food carts and potentially allowing them within the city. I think folks were discussing, the lack of commercial vibrancy in the city that has a lot to do with, external sort of macroeconomic factors related to the commercial market and other issues. But, ultimately there was a desire to promote, more vibrant sort of business districts and restaurants in the city through, offering those kinds of opportunities for smaller sort of upstart food businesses. So, food carts were identified in all groups, I think, in some capacity. Not necessarily this is the first, priority, but it was an interesting outcome. So, of course, as they mentioned at the summit, all the input from that group will be considered at the council goal-setting retreat, and that's kind of what we'll then sort of take and sort of develop a work plan for the goals that are related to the Planning Commission. So, I think it's a little bit to be determined if that ends up on the council goal list of sort of goals that they're hoping to accomplish for this year, but that is certainly one really notable outcome from that summit meeting, and it was definitely worth sharing, so thanks for reminding me. Of course, lots of other discussion to come, so I guess that kind of relates to the schedule updates, and I can get into those if there's no
Any other
business.
questions before we move on? Okay.
So, I guess I will just say the next meeting we're going to be talking about on January 27th, so in 2 weeks, we'll have work sessions on both affirmatively furthering fair housing, education, and policy. We'll have a representative from the Fair Housing Council of Oregon provide a presentation to the Planning Commission on that issue. It's a recommendation that resulted from the housing production strategy last year, as I'm sure you remember. So that's something that we'll be discussing in a couple of weeks. We'll also have a work session as related to sort of the annual code amendments this year. One of the items that we sort of pulled out and wanted to take on its own track and become its own project was related to home occupation standards. So that's something that we'll have Associate Planner Michael McNamee also provide a presentation and conduct a work session with the Planning Commission on some potential changes to our home occupation standards here in the city. So that's what we have. Those 2 work sessions planned for January 27th. On February 10th, though, we'll be getting into that exercise where we're going to discuss what the council has determined their goals to be for this year following the council goal-setting retreat, and look at some work plans, or just discuss the work plan, a proposed work plan at least, to accomplish those goals as they relate to the Planning Commission. So really that work plan review session number 1, we've already kind of discussed this at the end of last year as well, so it shouldn't be completely new. But that would be on February 10th. On February 24th, we have scheduled the second work session on the home occupation standard, so hopefully comes to you with some more refined code concepts and language at that point, a little bit more closer to what we might see in terms of a code amendment at that point. So we'll have that second work session on home occupations on the 24th of February. And as Evan again just mentioned, we'll tentatively schedule the hearing for the annual code amendments for this year for 2024 and early 2025, I guess, for March 10th. So the annual code amendments that we discussed tonight would come to the hearing on March 10th for further sort of public testimony and deliberation by the commission. We'd also have our second work plan discussion with the commission, work plan review, so we can make sure that that what staff is putting together in terms of that work plan is reflective of what you all want to accomplish this year at the Planning Commission. So that brings us into March, and then of course, one thing I want to point out, we ended up postponing the work session on the implementation of the housing production strategy, pushing it back about a month to March 24th. So that's currently on the schedule for March 24th right now. We also were planning to adopt findings, if all goes well, for the hearing on the annual code amendments, to adopt findings for the annual code amendments on the 24th of March. So that puts us out to the end of March. We have a lot kind of planned here this year. A lot has to be determined for a lot of these projects. One thing I wanted to point out, just in terms of an update of business that has come to the commission and is now on hold. So the FEMA from National Flood Insurance Program Flood Hazard Management Code Amendments are currently on hold. We are awaiting further direction from, I think, and correct me if I'm wrong here, Evan and or Jessica, both the state and the federal government, FEMA, on what the sort of model ordinance language will be and whether or not it's considered to be sort of meeting our clear and objective standards for housing here at the city. So, or here in the state of Oregon, rather. It's not just the city that has to comply with those. So anyway, there's some unanswered questions, and we just wanted those to be settled before we brought it to a final hearing. So just wanted to let you know we've conducted a hearing and adopted findings here at the commission for that, but it's on hold in terms of the final adoption at the council. Another thing I would just point out is that we have a new project on here, the Foothills Refinement Plan. That is something that we will be discussing sort of at various stages this year. I think will become a little bit more active of a project here at the Planning Commission, and something that will also be, it was kind of previously within the realm of the redevelopment agency and the redevelopment manager at the city. It will still be, of course, an urban renewal related project, but I will now be managing that project, and we will be talking about that a little bit more this year, and it is a multi-year project. So the aim is to get something adopted there by the end of 2027, likely fall of 2027. So something you'll be hearing a lot more about in the coming years. So yeah, just a few things to flag that are new on the forecast and a lot of to be determined there that we hope to flesh out in the coming weeks. And that's it.
That's happening March 24th.
Yeah, it looks like I think it'll be very brief updates on a number of those items. So it's, generally an HPS implementation update, but, it does pertain to a lot of different things that we signed up to do with that HPS. So, probably won't be super in-depth on any one of those, but we'll cover a lot of bases.
Okay, thank you very much. Well, with that, the meeting is adjourned. Thank you.